Hello and welcome to this UGCE PG Pathshala project on law. I am Neeraj Tiwari and I will be presenting module on victims of crime. The learning objective of this module are: first, we will understand that why and how victim justice became a casualty in criminal justice discourse, and we will also see that what led to victim justice getting recognition by the last quarter of the 20th century, how the victim justice ideas were incorporated in the Indian legal system, and also how the Indian judiciary has responded to victim justice needs and victim concerns. In the primitive societies and in the Anglo-Saxon period, justice was not privatized and redressal for wrongs was totally in the hands of victim. With the growing complexities and increasing difficulties of collection of evidence and bringing the wrongdoers to justice, the idea of private justice was replaced by public justice, in which the state functionaries took upon themselves the responsibility of investigation and prosecution of crimes on behalf of the victims. This way, victims' interests subsumed in state action. Under the new dispensation, the criminal justice became preoccupied with pro-accused orientation and victim became ignored. The idea of this module is to take you through different provisions of the Code of Criminal Procedure which has been inserted through different period of time to recognize victims' plight and right. There are many provisions which are added in the present CRPC which were not there before, and it is only late initiative taken by the judiciary and legislature that these provisions are inserted in the Code of Criminal Procedure as it is now. But before we discuss the Indian position, let us first talk about the UN Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power of 1985. This document talks about four major needs of crime victims, and these are access to justice and fair treatment, restitution, compensation and assistance. And I will try to locate these four needs in our criminal justice system through different provisions. We will also see through different analysis of provisions and judicial pronouncements that how far we have reached and how far we are successful in incorporating provisions redressing these four needs of crime victims. Now, many countries in the world have enacted special legislations as far as victims of crime and witnesses are concerned, and these legislations are mostly inspired by UN Declaration of 1985. As far as India is concerned, the impact of UN Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power is concerned can be seen through different documents which led to finally insertion of certain provisions in the code as well. So, to take you through these documents, let us discuss first the 154th report of the Law Commission of India which came in the year 1996. In this report, the Law Commission advocated for need for victim oriented justice delivery system. Law Commission has also recommended for payment of compensation out of state's fund. In 2003, in Malimat Committee report on reforms of criminal justice system, once again the plight of victim is taken into consideration, and it was recommended in the report that participation of crime victims at various stages of criminal justice system should be considered. At the same time, expansion of principle of compensation to crime victims were also recommended by the Malimat Committee. So, it can be seen that from Law Commission to Malimat Committee report, and also it can be seen that the clear impact of UN Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power can be seen in the recent changes made in the year 2008 by the Code of Criminal Procedure Amendment Act of 2008, by which different victim oriented provisions were inserted in the code. These were section 2AA which defines victim, section 24(8) proviso which provides for legal assistance to victim, section 372 victim's right of appeal, and finally section 357A which talks about victim compensation scheme. All these provisions will be discussed in detail in this module. Let us begin with the definition of victims of crime. UN Declaration defines victim in following terms: persons who individually or collectively have suffered harm, including physical or mental injury, emotional suffering, economic loss or substantial impairment of their fundamental rights, regardless of whether the perpetrator is identified, apprehended, prosecuted or convicted. Regardless of the familial relationship between the perpetrator and the victim, victim also includes the immediate family or dependents of the direct victim and persons who have suffered harm in intervening to assist victims in distress or to prevent victimization. As we can see, the definition clearly describes or defines victims in a very broader perspective. Now, if we compare the definition of victim given under the UN Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power with that of definition under the Code of Criminal Procedure as given under section 2WA, we will find that the definition of victim under the Code of Criminal Procedure is narrow in approach, and on two counts I would say that the definition is really limited in its sense. First, for a victim to be treated as a crime victim in India, the person or the perpetrator must be charged as given in the definition itself, whereas in case of UN Declaration the definition is an open ended and it is regardless of whether the perpetrator is identified, apprehended, prosecuted or convicted, the person will be treated as a victim. And secondly, when it comes to the Indian definition, is the expression victim includes his or her guardian or legal heir. So, again it is in very legal sense the other persons or relatives are added or included in the definition of victims. Now, if we compare this expression victim which includes his or her guardian and legal heir as given under the Indian definition with that of UN Declaration definition of victims of crime, we will notice that in case of UN Declaration, victim also includes the immediate family or dependents of the direct victim and persons who have suffered harm in intervening to assist victims in distress or to prevent victimization. So, the definition is very broad as given under the UN Declaration, and it not only includes the legal representative or the near dear relatives of the victims, but it also extends and covers those who have assisted the victim from victimization. So, it is a very broader in perspective and could have been considered at the time of framing the definition of victims of crime as far as India is concerned. Now, if one traces the rights of victims in criminal justice system, there may be the following rights which can be referred to. First, right to access to justice and fair treatment. Second, right to participation. Third, right to be informed. Fourth, right to legal assistance. Fifth, right to medical, psychological and social assistance. Sixth, right to compensation, and lastly, right to restitution. In my talk, I will discuss all these rights separately and will try to comprehend with different provisions as given in the Code of Criminal Procedure. Now, to begin with the first and foremost limb or need mentioned in the UN Declaration, that is access to justice and fair treatment. Now, access, justice and fair treatment as defined in clause 4 of the UN Declaration, if we try to trace the same in Indian position or Indian law, then we will find that first and foremost section 154 of the code is very important, where a victim or informant of a cognizable offence can give information to a police officer about the same, and such information must be reduced into writing signed by the victim informant who gets copy of the FIR free of cost. So, therefore, as soon as the victim has suffered any harm, he can approach the police officer to report the incident, and at the same time he will be provided with a copy of the FIR free of cost. Now, certain special reporting procedures were added in the year 2013 pertaining to sexual offences in section 154 of the code, which provides that where information is given by a woman victim of an offence of acid attack or sexual harassment or rape, then such information shall be recorded by a woman police officer or any woman officer, and where such woman is temporarily or permanently mentally or physically disabled, then such information shall be recorded at her residence or at a convenient place of her choice in the presence of an interpreter, and at the same time the same recording of statement must be videographed as well. Now, a welcome provision is added in the Indian Penal Code by the same Amendment Act of 2013, which prescribed for punishment for those officers who refuse to register FIR in these cases. Such a provision can be found in section 166 capital A subclause C of the Indian Penal Code, which prescribes punishment for minimum 6 months and up to 2 years rigorous imprisonment. Now, other than these statutory provisions, in the case of Lalita Kumari versus Government of UP in 2014, even the Supreme Court has made it very clear that it is mandatory to register FIR in all cognizable cases under section 154 of the code. Therefore, a police officer cannot refuse from registering an FIR of an information which discloses commission of a cognizable offence, and action must be taken against erring officers who do not register FIR in such cases. So, we can say that section 154 and Lalita Kumari case both have fortified the procedure for reporting of crime in cognizable cases. Now, after reporting of crime, if we try to trace the victim's role in investigation process, we will see that victim's participation in the investigation is completely dependent on the need of the investigating authorities. So, where the victim is required for any purpose by the investigating agency, he may be called upon by the police officer. But in section 157 subclause 2, the police officer is duty bound to report or inform the informant or the victim if he refuses to investigate the case for whatever reasons. Therefore, where the police officer takes a decision not to initiate investigation on an FIR registered, he must notify the victim of the same. Another important development in this regard is the case of Bhagwan Singh versus Commissioner of Police, 1997 decision of Supreme Court, where the court has stated that in cases where the police officer has filed a closure report or where the magistrate decides not to take cognizance of the offence on a police report, the court has recognized the right of victim or informant to receive notice about such decision. Therefore, in all these circumstances where the police decides to file a closure report or where the magistrate decides not to take cognizance on a report submitted under 173, it must be notified to the informant or the victim of the same. Now, after discussing the role of victim in investigation, let us see role of victims during trial. Now, victims are merely seen as an informant who set the wheel of justice in motion. Their role is limited to that of prosecution witness. It is the prerogative of a state to prosecute the accused. State appoints prosecutors to plead on behalf of the victim as well. In our country, the right of representation by lawyer is a fundamental right of every accused person, but the victim is not even allowed to prefer a lawyer of his choice to argue his case. Section 301, 2 and 302 give some scope for the intervention of the victim in the trial proceeding by allowing him to appear or appoint a pleader. But the pleader so appointed can only act under the directions of the public prosecutor. In 2008, a significant development is seen when a proviso to section 24 subclause 8 was added in the Code of Criminal Procedure to enlarge the scope of section 301 and 302 of the code. The proviso provided that the court may permit the victim to engage an advocate of his choice to assist the prosecution under section 24 subclause 8. Thereby, now the victim has also a chance or right to appoint a pleader who will be assisting the prosecution throughout the trial. This way, he can work as a watch advocate who throughout the trial will look into the development or of the case, or he may assist the prosecution in a way that the victim's right are also addressed during the trial. Now, let us see some other important phenomena or processes during trial where victims' right can be given recognition. First of all, it is plea bargaining. The provisions relating to plea bargaining in the code are also crucial as far as victim's role is concerned. Under section 265 capital C of the code, the victim is required to be served with a notice to participate in the meeting to work out a mutually satisfactory disposition of the case, including payment of compensation agreed. The victim is allowed to participate in such meeting with his pleader as well. Therefore, it can be seen that in plea bargaining proceedings, victims' rights are duly recognized by the code. Now, coming to the role of victim in bail proceedings, it can be seen that in granting or cancellation of bail, victims have substantial interest though not fully recognized by law. At the time of hearing on bail of the accused person, victim is not given an opportunity to present his case before the court, meaning thereby he is not allowed to state the reasons for cancelling the bail or for not granting the bail to the accused person. Though section 439 subclause 2 may allow a victim to move the court for cancellation of bail, but the action thereupon depends very much on the stand taken by the prosecution. Similarly, in cases of withdrawal from prosecution is another crucial stage in criminal trial. So, in such cases where the prosecution can seek withdrawal from prosecution, he need not to consult victim. Such withdrawal may either be generally or in respect of any one or more offences. Victim seems to have no right to challenge the prosecution decision at the trial stage itself. Therefore, as far as withdrawal from prosecution is concerned, it is the prerogative of the prosecution to take a call on whether he is going to proceed with the case against the accused or not, or whether he is going to charge the accused for one offence or another. That is the prerogative of prosecutor only, and victim has no say in that. Therefore, the matters relating to bail and withdrawal from prosecution are two different stages where victims' rights can be recognized or victims may be given a more crucial role to play as far as victims' rights are concerned. Now, victims' right to appeal. In the year 2008 itself, by an amendment to the code, a proviso to section 372 was added, which recognized for the first time victims' right to appeal in cases where the accused has been acquitted, or where inadequate compensation is awarded, or where the accused is convicted for a lesser offence. The said proviso does not provide for victims' right of appeal for enhancement of sentence, which still remains the prerogative of the state under section 377 of the code. There are certain issues with this right of appeal of the victim. The first and foremost is whether victim's right to appeal need to satisfy the requirement of leave to appeal under section 378 of the code or not. Secondly, whether his right to appeal is independent of or subservient to the right of the state. And thirdly, where the victim is also the complainant, whether he needs to apply for special leave under section 378(4) or he can directly file an appeal under the proviso to section 372 of the code as a victim. So, these issues are yet to be decided in light of victims of crimes right to appeal. Now, role of victim in sentencing process. Indian criminal procedure law gives opportunity to an accused person to be heard on quantum of sentence under section 235(2) and 248(2). In countries like United States and England, victim's statement is taken into consideration while sentencing the accused. In United States, it is known as victim impact statement, and in England, it is called victim personal statement. In India, victim is not given any such opportunity to be heard at this stage of sentencing. But in the year 2000, in this case of state of Andhra Pradesh versus Polamula Raju, the Supreme Court stated that it is an obligation of the sentencing court to consider all relevant facts and circumstances bearing on the question of sentence and impose a sentence commensurate with the gravity of the offence. The sentencing court must hear the loud cry for justice by the society and more particularly in cases of heinous crimes of rape of innocent helpless children of the victim of crime and respond by imposing a proper sentence. Therefore, indirectly in this case the Supreme Court has somehow opened the gate for hearing the victim of these heinous crimes at the time of sentencing as well. Now, let us come to compensation. Now, compensation is provided under section 357 and 357A, which are repository of compensation to victims of crime in India. Section 357A is a newly inserted provision, whereas section 357 was there before, but there were certain limitations under section 357 which requires discussion here. Now, section 357 has limitations like compensation can be awarded only when the offender is convicted and sentenced. The sentence of fine can be applied in the payment of compensation only when compensation is recoverable by the victim in a civil court. Same way, where the fine does not form part of the sentence, the court may order the accused to pay by way of compensation an amount to the victim. And lastly, the payment remains suspended till the limitation period for the appeal expires, or if an appeal is filed till the appeal is finally disposed of. Now, the development in this regard was made by section 357A are worth noticing. Now, section 357A provides that every state government in coordination with the central government prepare a scheme for victim compensation. Where compensation awarded under section 357 is inadequate or where the case ends in acquittal or discharge and the victim has to be rehabilitated, court may make recommendation to compensation. Where offender is not traced or identified or no trial took place but the victim is identified, he may apply to the state or district legal service authority for award of compensation. Similarly, the state legal service authority or district legal service authority may order for immediate first aid facilities or medical benefit to be made available to the victim free of cost on the certificate of a police officer or a magistrate. Therefore, certain improvements have been made by section 357A in the existing position which was there in the code under section 357. So, the legislature has tried to remove the limitations which were there in section 357 by bringing section 357A in the code. Now, let us see the response of court as far as victims of crime is concerned. Now, with regard to section 357, the court has noted in the case of Hari Singh versus Sukhbir Singh that the power of courts to award compensation under section 357 is not ancillary to other sentences, but it is in addition thereto. It is a measure of responding appropriately to crime as well as of reconciling the victim with the offender. It is to some extent a constructive approach to crimes. Similarly, in the case of Ankush Shivaji Gaikwad versus State of Maharashtra, in 2013, the Supreme Court has stated that the provisions dealing with compensation to the victims of crime confer a power coupled with a duty on the courts to apply its mind to the question of awarding compensation in every criminal case. The trial judge must record his reasons for awarding or refusing compensation. Now, a question which has come up before the court for a number of times was whether a sentence in default of payment of compensation can be passed or not. Now, in the case of R. Mohan versus A. Vijay Kumar and Roy Fernandez versus State of Goa, this matter has been settled. And in R. Mohan versus A. Vijay Kumar case in 2012, the Supreme Court has stated that where the accused fails to pay compensation so ordered or not willing to pay the same, the court can impose a sentence in default of payment of compensation as it can be done in case of default in payment of fine. Even in case of Roy Fernandez, the court, while reducing the sentence of the accused to the period already undergone, ordered to pay compensation to the victim's family. In case the accused fails to pay such compensation, then the sentence of 1 year awarded to him shall stand revived. Therefore, it is very clear that in all these cases where compensation is ordered to the victim to be paid by the accused, and the accused fails to pay the same or refuses to pay the same, he may be sentenced to imprisonment in default of payment of such compensation. Now, let us discuss the criteria for fixing quantum of compensation. Now, there is no such criteria provided in the code, but the court through various cases have devised a mechanism for awarding compensation or for fixing quantum of compensation to be awarded to victims of crime. Now, these criteria are like nature of the crime, injury suffered, justness of the claim for compensation, and finally capacity of the accused to pay the compensation. So, these are certain criteria which are considered by the courts while fixing the quantum of compensation to be paid to victims of crime. Now, another important development with regard to compensation is payment of interim compensation. Of late, the courts have recognized payment of interim compensation more particularly to victims of sexual offences. In the case of Bodhisattva Gautam versus Subra Chakravarti in the year 1996, the Supreme Court has stated that if the court trying an offence has jurisdiction to award the compensation at the final stage, there is no reason to deny the court the right to award interim compensation. The jurisdiction to pay interim compensation shall be treated to be part of the overall jurisdiction of the court trying the offence. Therefore, in cases of sexual offences, the victim can be awarded interim compensation and she need not to wait till the trial gets over. Now, coming to restitution. Now, restitution means putting the victim in his or her original position. It is presumed that law will make fair restitution to victims, their families or dependents, which include the return of property or payment for the harm or loss suffered, reimbursement of expenses incurred as a result of the victimization. But so far, restitution is not recognized as a sentencing option in addition to other criminal sanctions, and it still depends on the discretion of the court to make restitution part of sentence or not. As far as assistance is concerned, which is the fourth and last need as mentioned in the UN Declaration, which speaks that victims should receive the necessary material, medical, psychological and social assistance, and victims should be informed of the availability of health and social service, is also well reflected in India under section 357A subclause 6, which requires the state legal service authorities and district legal service authorities to provide to victims of crime immediate first aid facility or medical benefits free of cost on the certificates of the police officer or a magistrate of the area concerned, or any other interim relief as the appropriate authority deems fit. Now, section 357C is also very crucial in this regard, which extends the obligation on all hospitals, whether public or private, to provide the first aid or medical treatment free of cost to the acid attack victims or victims of sexual offences. Any failure to provide such facilities under section 357C will attract punishment under section 166 capital B of the Indian Penal Code. Now, in this regard, two cases are really important to discuss, and both are named Lakshmi versus Union of India, one of the year 2013 and another of 2015. In 2013 Lakshmi versus Union of India case, the Supreme Court has shown its distress on the fact that the victim compensation scheme prepared by various states provide meager compensation to victims of acid attack, and directed that they shall be paid compensation of at least 3 lakhs by the concerned state government as the aftercare and rehabilitation cost. The court further directed that of this amount a sum of rupees 1 lakh shall be paid to such victim within 15 days of occurrence of such incident to facilitate immediate medical attention and expenses in this regard. Similarly, in the year 2015, in the case of Lakshmi versus Union of India, the Supreme Court has held that the private hospitals should provide full treatment to the victims of acid attack, including medicines, food, bedding and reconstructive surgeries. The hospital where the victim of an acid attack is first treated should give a certificate that the individual is a victim of an acid attack. A criminal injuries compensation board known as CICB to be established at the level of district legal service authority to decide the matters pertaining to compensation claim made by any acid attack victim. Now, let us discuss the second level of victims, which are victims of abuse of power, as mentioned in the UN Declaration of Basic Rights of Victims of Crime and Abuse of Power of 1985. Now, as far as victims of abuse of power is concerned, clause 18 says victims means persons who individually or collectively has suffered harm, including physical or mental injury, emotional suffering, economic loss or substantial impairment of their fundamental rights through acts or omissions that do not yet constitute violations of national criminal laws, but of internationally recognized norms relating to human rights. But in our country, we have yet to import clause 18 of UN Declaration of Justice for Victims of Crime. In this regard, role of constitutional courts are very important, and in many instances the constitutional courts have extended their writ jurisdiction and awarded compensation to the victims of abuse of power as a public law remedy. The case of Rudal Shah is well known in this regard, and in this case the Supreme Court recognized the need for compensation in cases of abuse of power by the state machinery and directed the state government to pay compensation to the victim for illegal incarceration for long years. Similarly, in the case of Bhim Singh versus State of J&K, illegal detention in police custody was held to constitute violation of Article 21 and 22 subclause 2 of the Constitution. The court, in exercise of its power under Article 32, directed the state to pay compensation to the petitioner for violation of his constitutional rights. Other cases which are pertinent in this regard are Nilabati Bera versus State of Orissa, and the law on award of compensation for abuse of power was crystallized in this very case. In this case, the deceased was arrested by the police and kept in a police custody. The next day, his dead body was found on a railway track. The court treated it a case of custodial death and awarded compensation to the mother of the deceased. But regrettably, in the case of Mehboob Bakhcha versus State represented by Superintendent of Police, a 2011 decision of Supreme Court, which was a fit case where the apex court should have invoked its compensatory jurisdiction in cases of abuse of power by the police machinery, who do not only beat the victim to death in their custody but also gang rape his wife, but the court has not considered this case as far as compensation to the wife of the deceased was concerned. But in an old case of 1995, the case of State of Punjab versus Ajab Singh, the court has granted compensation even where it was not asked by the victims. It is a laudable example of proactive judiciary where the Supreme Court awarded compensation even in case of acquittal. The case involved killing of two police officers by another police officer. The Supreme Court upheld the order of the acquittal passed by the High Court, but directed the respondent to deposit a sum of ₹5 lakh with the registrar of the High Court for the purposes of payment to the dependents of the deceased. Therefore, it can be seen that the victims of crime have gained attention of lawmakers worldwide. Many countries have enacted legislations exclusively addressing the needs of crime victims. In India, the movement for recognizing need for crime victims has started after UN Declaration came into existence. The judiciary has played a major role in establishing victims of crime as a separate stakeholder in criminal justice process. The judiciary marched ahead of legislature in evolving and conferring procedural rights on crime victims. Such proactive step on judiciary was supported by various recommendations of Law Commission and Malimat Committee. Of late, the legislature has brought some key changes in the procedural criminal law to address the plight of crime victims, making crime reporting mandatory, giving opportunity to victims' counsel to appear before the court, providing independent right to victims to appeal, award of compensation even in cases of acquittal or where the accused is not traced, victim compensation scheme are some of the instances of recent progressive steps taken by the legislature in recognizing the rights of victims of crime. Now, the victims are not seen merely as an informant or witness for prosecution, but they are holders of such procedural rights which can move the machinery of criminal justice on their own. but still the country hopes for a comprehensive scheme for victims of crime on the line of legislations enacted in other countries which recognize victim participation at all stages of the criminal process. Thank you.